Okay, so that's a threshold question. Right? Before you get into any of the substance, someone needs to have. So what do you think? Does Marbury have standing?
According to the Judiciary Act of 1789, he does.
Yeah.
Although, again, that is a major part of the case as a whole. So
yeah.
That's addressed later. But currently he does, in terms of the current law.
Yeah, the current law and the current law goes all the way back. So this is sort of opening question of whether he has standing. And the key thing is, one thing that gives someone a standing is an injury. Okay, and that's part of when the Constitution says that the courts, Article 3 courts, will have jurisdiction over cases and controversies. In order to have a case or a controversy, and not just a theory, you need to have an injury. Okay, and let me pause there. I didn't anticipate talking about this in any detail, but I'm actually working on a case now where standing is the big problem. And so just to tell you, have you heard about the emoluments suits against Trump? So what happened, the Constitution says that no officer can receive titles or presents, titles of nobility, presents, from a king, prince, or foreign state. And the question, the substantive question, the content of that question is whether the Trump hotels, which when they receive money from the Saudis or from the Qataris, etc., is that money going to the Trump hotels a violation of the Foreign Emoluments Clause? And when the state of California spends money at a Trump hotel, does that violate the Presidential Emoluments Clause of a state or Congress giving a president benefits? That's the substance. The first problem that we're encountering in this case is not the constitutional question, but who has standing to. What's that?
Like ask you. Sorry.
No, go ahead.
Like even if he didn't violate this, like who's actually getting injured by him getting
Yeah, exactly. Who's injured if the president is getting money from Saudi Arabia and it violates the Constitution? You still need someone with an injury to bring a case or controversy. So I'm helping with a group of hotels and restaurants that say when Saudi Arabia's officials go to the Trump hotel and they don't go to our hotel or they don't go to our restaurant, we're injured because of the president using his status. And two attorneys general have said, our states are hurt by these emoluments clauses. So anyway, this is a hugely important question right now, and so it's good that we started with that. But then once we have the procedural step, right, saying that you can get into court, then we have three substantive issues. Okay, so yeah, what are those three substantive steps?
Does the case have merit?
So that's the big. Does the case have merit? Is sort of the big question.
So that's how we talked about it as being standing and merit.
Yeah.
Can it be there in the first place, and then how should the court rule, and what should the court do with it?
Yes. So on the merits, there are then three steps to figuring out if Marbury's case has merit. So what are those? Yeah. So someone new. Anyone else? Yeah. Go ahead.
Was he wronged in this?
Was he wronged? So what? And so what's the wrong here?
That he is owed a commission that he does not.
Yes. Okay. The first question is, does he have property in a commission? And so, what word goes with wrong? What's the right? What's right and wrong? So if he's wronged, it's because he has a right. So the first step is, does Marbury have a right to this commission? And this is a property question, right? Not like real estate, not like owning land. That's traditionally what we think about as property, or hard concrete goods, or intellectual property. This is a property in an office. So it turns out you can have it. The court says, right, that he does have a property right to the commission. It's sealed, it's stamped, and it was delivered. So it wasn't delivered, but once it was sealed and stamped, right? So the problem was it wasn't delivered. So can you have property when something was supposed to be given to you and not delivered? Who didn't do the delivery that he was supposed to do? Yes, what's your name?
Ben.
Ben, go ahead.
James Madison didn't, or actually both John Marshall and James Madison.
The first two people.
His, but he delivered the other one.
What's that?
He delivered his,
Yeah,
but he
he
delivered the
remembered
other
to
one.
deliver.
So just turns out, Secretary of State Marshall then becomes Chief Justice, and he's now, so one of the many weird things about this case is that you've got a Chief Justice who is ruling on his own failure to do something. So just a note on this, it's interesting, he says, no harm, no foul, at least as far as this goes. Right? Don't blame me, even though I didn't deliver the commission, he still has a right. So he's kind of fixing his own mistake with his own legal ruling. One question is whether he was biased in making that step, but that's a separate question. Okay, so then he has a right, so then we need a second step. What's the, yes, Jacob, go ahead.
Is there a way to redress this wrong, like
Yes.
a writ of mandamus per se?
Yes. If there's a right,
Spitballing here.
That's a pretty.
right, so then we get Latin, this comes up a lot. Where there's a right, there should be a remedy, right? So the Latin is ubi jus, ibi remedium.
I like that.
Yeah, that's good.
You like that?
That's good.
We love foreign language. Okay, so that Latin, where there is a right, there is a remedy, and this is a proposition that people cite going back to Marr, but it goes way back before it.
I was just going to say the third one.
Yes.
If there is a remedy, is it this court offering
Yes.
A writ of, or issuing a writ of mandamus?
Good. Jurisdiction. Mandamus. So what's the problem there?
Number 3.
Yeah. Yeah. Go ahead.
Oh well, in the context of this case, it's yes, the Judiciary Act of 1789 gives the Supreme Court the right or original jurisdiction in all cases regarding issues or writs of mandamus. But is that something that is not actually outlined in the Constitution? Is that something the Supreme Court that Congress actually has the right to give to the court?
The U.S. Constitution, Article 3. So even if the statute creates the power for this court, the Supreme Court, to issue a writ of mandamus, but is that consistent with the U.S. Constitution? So let's say more about why that might be a problem. What's your name?
I'm Matt.
Matt, go ahead.
Well, two things. So one, it would be a problem because in Article 3, Section 2, it says that the Supreme Court only has original jurisdiction over cases involving ambassadors and foreign consuls. But beyond that, also just practically, the way that this writ of, feasibly, Madison could just deny to issue the writ of mandamus, and then Jefferson, who's also a Democratic Republican, would refuse to send the army on Madison to do that. So really, there's no way out of this, and I think that's, some people said that's one of the reasons that judicial review starts.
Good, exactly. So if we put this case in the political context, there is something that Marshall pulls off that's a bit of a judicial sleight of hand, right? He doesn't have the power. He doesn't have an army, right? The Federalist Papers call the judiciary the least dangerous branch. So so when you say
Until this point.
It's up to this point, and still, right? Who has an army, right? You said the great example you just suggested was Jefferson wasn't going to sick his army on Madison, right? So that raises the question of what are the other dangerous parts of the government? The president has, as commander-in-chief, has the military, and so what does Congress have? What does Congress? Yeah, go ahead, keep going. What does Congress have?
Check and balance.
Congress has, and not only does it have check and balances, it literally has the checks. It writes the checks.
I'm saying, are you asking what
Yeah, right.
powers?
But what the core power that Congress has
To make the laws.
is make the laws and also the spending power. Right?
Yeah.
So it makes so absolutely it makes laws, but the big thing in terms of its practical abilities, the president has the army. Congress, in addition to passing laws, it can control budget. It can starve the courts if it wants to. You know,
And directly impacting the courts, it can also propose constitutional amendments, right?
You can propose it, right? You still need the states. Yes.
But also, you could argue that the executive branch's power is limited by swearing an oath to the Constitution.
Yeah.
Even if the commander-in-chief goes rogue and refuses to support what the court deems as correct, the army could completely constitutionally not listen and do what the Supreme Court says.
It's true.
When
And,
that's
yeah, that's
feasible.
right. Yeah. So the question. So then, so this is getting really big picture. Then it goes all the way around to what the Supreme Court's power is, even if it's the least dangerous in terms of military or financial money. The Supreme Court has something else. and that relates to whether the president has the support of the military, or the president has the support of the people, or the court. There's something else that the court does. Yeah, go ahead.
So while the court has like a very kind of limited
Yeah.
area of power, like which only the interpretation of laws, like it has effectively absolute power in that whole, like.
In theory.
Yeah.
In theory. So how does it hold on? But how does it hold on to power in theory?
Like, because it has, frankly, because it has the option to choose what case to take. So. Like,
Okay, that's
like,
very important, right? So the Supreme Court has control over its jurisdiction. It has now more power. Then it was a little more complicated then. But the Supreme Court heard very few cases then. The number of cases increased, but now they've really gone back down because of that control. But what else? What do justices do? This is a big picture question. What makes a court a court? Yeah, go ahead.
They decide, like, I guess the will of the people,
Yeah.
or they interpret it at least.
Yeah.
And based on the laws and the fundamental values set out in our ruling document.
Great, fundamental values. All of this, I mean, I think all of this connects to what I was thinking about. And this is all another way of talking about legitimacy. And how do you get legitimacy? Persuasion, morals. So there is an aspect of what Chief Justice John Marshall is doing is he's struggling. He is in a very tough position in terms of his legitimacy, because he's got one party, the Federalist Party, that has one set of expectations, and he's one of them. On the other hand, you've got the Democratic Republicans that will punish him, and he has to then maintain his legitimacy by not just capitulating, not just surrendering, putting up a white flag. He needs to both announce a power and then not use it. Right? He needs to, and that's what happens in this case. He announced, so we just jump big picture pretty quickly. There's a step that I just want to make sure we have clear, which is this relationship between the just to hone in on this problem, the relationship between the 1789 statute and Article 3. And it's always important to just make sure when you make an argument from the text, from the Constitution, go back to the text of the Constitution. You did that, someone did that a little bit. Who mentioned original jurisdiction and appellate jurisdiction? Was that Izzy? No.
We both did.
You both did. What's your name again?
I'm Matt.
Matt, okay. So let's just, do you have it open? I
Yeah.
usually have my little pocket Constitution with me, but I don't have
Oh,
it.
Mr.
Good. Oh, let me get it. All right. Okay, awesome. This is a good one. I collect them, actually.
In other words, you're not getting it back to you.
Yes.
That's right.
It's
A
your
little bit like
thank you.
Putin and Robert Kraft in his in a Super
That's
Bowl
right.
ring. This is a great ring. I like
Out
it.
there.
Thank you. All right, so I'm in Article 1, Article. I mean, also, just for a minute, notice if you flip through your pocket Constitution, it's always interesting. Look how long Article 1 is. Right? Article 1 is about Congress. They go on and on. It goes on and on. Article 2, a little shorter, and then you get to Article 3, and it's barely it's a page and a half in these pages. So it's very short. So what's the key? Let's just focus on that for a minute about what the key clause of Article 3 is. Yes, go ahead.
In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction.
Yes. Okay.
And then there's
Keep
one
going.
more line. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make.
Regulations and exceptions. Okay. So why is the 1789 statute that gives the Supreme Court the power to issue writs of mandamus? Let's just be clear about why that's a problem. Yeah, what's your name again?
Eric.
Eric, go ahead.
Because it can be interpreted that this clause does not give the Supreme Court power to add cases to the court's original jurisdiction.
Right,
And that's
because-
the argument that Marshall's making.
Great. When the court, to issue a writ of mandamus, that is an original jurisdiction move. That's asking, that's the first court you go to, it's treating it like a trial court, they go to the Supreme Court and they say, we want to originate from this court. We want this court to originate this writ, to issue the writ itself. When normally that has to happen from a trial court. What we mean by original jurisdiction is that a trial court can originate a writ, What a writ is basically a writ is a document that is an official document that comes out of a court that's like a court order. Only to have original jurisdiction is to be able to produce that. And we know from the passages you just read that in all other cases, other than the small list you just read from that gives original jurisdiction, this writ of mandamus is not included in the categories, that narrow set of categories for originating justice, originating a court order. And so in this case, there's only appellate jurisdiction. And so the message is, we can't do this. So then the question is, who could? Supreme Court says, we're not going to do this. And we're going to, just for a second, I'm going to spend a second. Someone asked a good question in the list. What about regulations and exceptions? Chief Justice Marshall doesn't talk a lot about this, right? So, you could say, if Congress can create regulations and exceptions, then why couldn't it just create a regulation or an exception for original jurisdiction? Any quick take on why? Why you think that's not possible? Yeah, Jacob again.
Well, at the very least, it's unclear if the regulations and exceptions is applying to original jurisdiction rather than just appellate jurisdiction.
That's a good reading, right? So you could say that it's only modifying this, but it doesn't modify. You can regulate and make exceptions to appellate. And let's say even if it applied also to expanding original jurisdiction, what would be an argument against that, Jacob?
That it can only reduce and make exceptions to where the Supreme Court would have original jurisdiction rather than as it is in 1789 Judiciary Act adding.
Yeah, I think that's a pretty good argument. I think that's one argument. I think you could also, I think that's great, that's probably sufficient. You also would worry that what happens, regulate and exceptions are moderate modifications. And when we say we think of modifying something as being a moderate step. A regulation exception is a small move. To give a court jurisdiction over a whole new class of things is more than an exception or regulation, but it basically would allow Congress to swallow up all the other limits of Article 3 and do anything. That's a much bigger move than what we might imagine from the word choices of regulations and exceptions. Matt.
I just want to ask you a couple of questions just about something you just said.
Yeah.
So when you say that that the word exception or regulation is a small kind of allowance to the Congress, can you speak a little bit to why you think that?
Yeah, well, let me give you an example. So I wrote an article about 15 years ago about the problem of 5-4 decisions, right? So if you think about the Supreme Court, there are a lot of, I see some nodding. Tell me about, I see you nodding. What's your name?
I'm Annie.
Annie, go ahead. What's up with 5-4 decisions?
Well, I don't know if this is what you're going to say, but I feel like the issue is if the Constitution said that this was to be interpreted, then how could just 9 people be deciding it's 5-4? There's barely a majority deciding everything for this decision.
Yes.
It's very it doesn't seem like it's quite fair.
So I had the same reaction. I'm not sure I still believe this, but 15 years ago I wrote an article that said the court should adopt its own rule that it can't overturn an act of Congress, let's say on First Amendment, free speech grounds, or for on grounds that it violates the 14th Amendment, et cetera, that the court should adopt a rule that it needs a 2/3 majority to overturn an act of Congress. And I said not only should the court adopt this rule, and I gave a whole bunch of reasons why that makes sense. Keep in mind how the structure of the Constitution works. Congress passes a law, and it needs the president to sign it. And if the president doesn't sign it, it doesn't become law unless Congress, by both houses, votes by a 2/3 majority, right? The Constitution has a principle that when you have two branches checking each other, you have sort of steps, right? A majority, then signing. If you want to override a veto, you need 2/3. So if that's a relationship between two branches, why should the Supreme Court, with only 9 justices, be able to override something that Congress and the President agreed to? Why should one branch be able to check the other 2, and not even, just by a bare majority, not 2/3? So I suggested not only should the court adhere to this rule, I also said Congress could pass a law that was using this regulations and exceptions to mandate. 2/3. So when I wrote this article, the big problem I had was that some people thought that this argument went beyond what a regulation exception would be. They thought that small, relatively smaller move about voting rights, about the voting power of the Supreme Court, which to me seems like regulating how the Supreme Court can make decisions. Many scholars who argue back with me said even that step is too far. So this goes back to Matt's question, right? If many people think that it's too much to impose a voting rule on Congress for something that on the Supreme Court for something it already has jurisdiction for, then basically giving the court jurisdiction over a whole new class of cases is even a bigger step. It's the kind of kol v'chomer, can we use a little Talmudic? It's like if this little step step is too much, then the chomer, the stronger step. Right? Who knew this was going to get Talmudic? Okay, keep going. What's
So,
Amy? Annie, go ahead.
You said that you aren't sure you believe in the whole.
Why do I now, just a word on that, I now have more concerns about democratic branches and authoritarianism compared to judges and the rule of law. So even if I have concerns about the current Supreme Court, I worry that if you use Congress's power to disable the Supreme Court from striking down unconstitutional moves, I'm worried about, I'm now more concerned that Congress and presidents can overstep their bounds, and limiting the court's ability to set limits on the other branches might be a bad thing for constitutional law. All right, that's a sort of learning from history and from the present moment. Yes, what's your name?
Alana.
Yeah.
What about the actual voting of the Supreme Court, not the power of Congress to overturn it, but just the voting of 6-3?
Oh, whether the court should adopt this.
Do you still believe in that?
I think the court should be. I think the court itself should be careful about how many 5-4 decisions it reaches, and it should. I think the court should value consensus more than it does. But I think that it should now. I think that it should do it more internally and not because Congress puts a limit externally. Matt.
So, I've just been thinking about this question kind of as we've been going through this unit and talking about judicial review.
Yeah.
Can you talk a little bit about the irony of the nature of judicial review? Because you're talking about how it gives the court so much power to overturn these laws with just these 9 people. So can you touch on that a little bit?
So when you say irony, so say more about what the irony is.
So judicial review is meant to give the court the power to try to uphold the Constitution, which in large part is in place to establish a system of checks and balances of power.
Right.
But judicial review is, a lot of people say, well, it gives the court judicial supremacy, which kind of upsets the system of checks and balances because there are fewer checks on the court.
Yes.
So that's why I kind of see the irony there.
This is again a bigger picture question, and let me do 2 things here. Let's first talk about the historical, use Barton versus Madison as an example of how these checks and balances played out in American history, and then use that discussion of what happened in 1803, 1801, 1802, 1803, 1804 as background for what could happen in 2020, 2021, 2022. Yeah, so let's take a big step back. And this is where the conversation was before. This is the thing so I wrote an article about this case and about what was happening in the states at the same time. So the states also are struggling with the same question. And it starts with the fact that, okay, Marshall writes this opinion saying there's a right, where there's a right, there's a remedy, and guess what? Mandamus is the remedy that can get you what you want. We can't give it to you. So then if you're Marbury, or if you're any of the judges who had been in office, put in office by Adams in 1801, and then suddenly you lose your jobs, wouldn't you look at this decision and say, would you be happy or sad from this decision? In theory, right?
Sad.
Sad. Okay, so why sad?
You can't get your appointment.
You couldn't get it, but why happy? Yeah, what's your
democracy didn't collapse, and that's pretty cool.
So okay, that's true. But you just want your job, right? Yeah. Ben. Max, sorry, Max. Go ahead.
The Supreme Court has already concluded that there is a remedy.
Yeah.
they just can't issue it.
Right.
So you just need to go somewhere else.
You
to
just
get
go
that remedy issued.
all right, so where do you go now?
Lower court.
The problem
court.
is they kind of are the lower courts, or they previously were going to be the lower courts, and now the lower courts might be Democratic Republicans who are unlikely to give them their jobs.
These district court judges, there are a lot of Federalist judges.
Okay.
So Washington and Adams have been president for 12 years, and they've appointed almost the entire judiciary. And not only that, they then added more. Now that they were taken away, but most of the federal district courts are Federalists who would be sympathetic to these. Yes, go ahead.
But then isn't it like the same problem that like the Supreme Court had? Because if the Supreme Court doesn't have the power to get him his seat, like there's no way that like a district court could like even if they ruled in favor of him and said you are entitled to this seat and you're entitled to like the writ of mandamus to get like the commission, they don't have power to like get Madison to hand over the commission.
Well, so what you've jumped to is a question, why, the next step for these plaintiffs, the people who want their offices back, is they could, in theory, go to district courts, and those district courts have original jurisdiction, and because they have original jurisdiction to originate a writ of mandamus and have a piece of paper that says, give me my job back. Marbury could do that. In fact, you've seen Stewart v. Laird. That's kind of a weird case where it's not the judges themselves, but it's about the circuit riding. So they don't get Stewart v. Laird doesn't give them their job back either, but it sends a signal, we're not going to take these claims seriously. Right? Stewart v. Laird. In many ways, Stewart v. Laird is the bigger problem to explain why these judges don't get their job. Because when the Supreme Court heard the question, did the midnight judges have a right to their court, to their offices, the Stewart v. Laird case sends a signal, we're not going to take that claim to your office seriously. So here's one way to piece it together. In light of Marbury versus Madison, that was in theory good news for these plaintiffs. But Stewart v. Laird was very bad news. Right? Because at the same time, just in the decision that was issued earlier, it basically says, we're not going to take your claim seriously to getting your job back that you already had of being a judge and riding circuit, instead of riding circuit. And so that signal is one reason why these many plaintiffs don't take the next step of getting that piece of paper, because they know that first of all, they can't rely on those courts to take it seriously, and even if they got that piece of paper, the politics of that paper, the politics of enforcing it, are not in their favor. But there's also a bigger question too, which is what else is happening politically at the same time. Ben? Eric, sorry.
Going off that same route about the politics, one discussion that we're having in this class is about how politics should influence legal decisions.
Yes.
And if politics should influence legal decisions, or if legal decisions should strictly be up to interpretations of law, and or like how the biases of those interpretations take effect.
Yep.
What is your opinion on how politics should play a role?
So I'm gonna punt your question about now back. Let's keep talking about 1803.
I mean, it's about both.
Yeah, it's about both.
Yeah.
So let's use the 1803, what's happening in 1803, to highlight the question now first, and then I want to make sure I get to that question, Eric. What's happening in this moment that is going to affect the Federalist plaintiffs in terms of the political checks and balances? Yeah.
Both Congress and the President are in the hands of Democratic Republicans.
Okay, and the Democratic Republicans in Congress are starting to use their power to check and balance the courts with impeachment.
And in 1802, they just didn't let them sit.
Yeah, so the first step was repealing the Judiciary Act of 1802. So one thing, right, so that may have been, the problem there is that might have been unconstitutional, but they still took the political step, right? So they repealed that act, and then the next, and this is, I think, really important in the next step. So first of all, the thing that I was studying was, this was not in isolation. The state courts were doing this at the same time. So several states flipped from Federalist to Democratic Republican at the same time. Maryland did the same thing to its Federalist judges. It repealed and removed judges from the courts by repealing the statute that created them. So they removed a whole bunch of judges from their office. So repeal and basically removal is happening on the federal level. It's happening in Maryland. In Pennsylvania, they start impeaching Federalist judges, removing them from office in a huge battle around the same time. And then you have federal impeachment. You have an alcoholic judge from New Hampshire who gets impeached and removed. And then the next thing you get is you get a Supreme Court justice, Samuel Chase, who gets impeached and almost removed. So this is, the Federalists are saying, wait a second, instead of trying to get some jobs back on lower courts, we now have a concern about the politics of whether we get to keep the Supreme Court itself. Instead of making sure we add jobs, we're now worried about losing all of our jobs. And Chief Justice Marshall knows that this is a big problem. That if they have the power to impeach and remove Supreme Court justices, they can remove the only branch. So Chief Justice Marshall has to be very careful not to overstep the line in terms of the politics of the moment, because that's where he has to navigate. So this is the sleight of hand he plays. The sleight of hand is, I'm going to make sure that I don't do anything myself that will earn the wrath of Jefferson. But I'm going to plant a seed of a power, I'm going to make judicial review come into being at this moment so I can preserve a power for later. Now, does Chief Justice Marshall ever use that power again? Does he ever strike down another act of Congress? No, he doesn't.
We haven't gotten that far.
Yeah, so the preview is he sends a signal about this power and he never uses it. But he does use the power for the Supreme Court to strike down state laws. So that's a significant move. So you have a whole bunch of good questions. I just wanted to make sure that we understood that this moment actually is a bit of a preview or a moment. We're going to be thinking about the role of the courts. And so if you're Chief Justice Roberts right now, what are you thinking about too? Right? This is I think let's jump now from this historical moment. What does Chief Justice Roberts today learn from this moment from Marbury versus Madison? What do you think he's thinking about, Jacob?
Well, does this play some role in kind of shaping his thoughts on how to act in a way that preserves the legitimacy and influence of the Supreme Court?
So today, right, Roberts is concerned with maintaining the legitimacy of his court after a series of major controversial election, controversy over the Scalia seat and keeping that seat open, then Gorsuch getting appointed last year, then the most controversial nomination perhaps in our history, which was Kavanaugh's. So there's a concern. Roberts is going to have to steer the same kind of position to preserve the court's legitimacy now.
Yeah, it's kind of like, it seems like Marshall was playing defense. Like he knew that he had to limit his own power as the Chief Justice in order to keep control of the Supreme Court and keep the legitimacy of the Supreme Court. And it seems like Robert kind of has to do the same thing.
I hear a sports metaphor in there. Yes, I think that's exactly right. I think that he's not trying to make gains down the field. This is kind of now. Usually in defense, right, you are worried about good offense. A good offense is a good defense here, right? So that's part of what he's doing is he's retreating from the moment here, but he's adding a good offense of judicial review down the road. So that's I think that's helpful. Okay, so we have a lot of questions here. Why don't we pause? Are there any more questions about Marbury versus Madison before we address some larger questions? And what's our timing? How much more time do we have?
We have until 45, so I think
okay, so we've got like 10, 12 more minutes?
Yeah.
Okay.
You get excused for next class.
Yeah, okay, so everybody's going to stay until lunch, so we're
So
about 12 minutes, yeah.
12 minutes, okay, so, Any more questions about this case? Yeah, Jacob.
Why, when the Democratic Republicans were trying to undo federalist influences in the judiciary, did they remove judges instead of like, whereas the midnight judges were 40, why didn't they just add 100 new circuit courts?
It's a terrific question. So essentially what happened was there was a big fight. And keep in mind, you've heard of a play called Hamilton, right? I mean, so you know that not only was this happening, you first had a big fight in 1801 where Jefferson became president even though he was voted by a majority of white propertied men, right? Let's just keep that in mind. With a bonus. Jefferson was also elected because he had a slave state bonus. So it's not clear if you take the slave state bonus of electoral votes, whether he wins by...
You're talking about the 3/5 compromise.
Yes, I'm talking about the 3/5 compromise that adds representation to the electoral college. But so Jefferson just got over one major constitutional fight. Then he's got this fight. Essentially what happens, and there's a book called The Jeffersonian Crisis, and it explains that there was, after this fight occurred, and the Federalists backed off, the Democratic Republicans also backed off. So there could have been other solutions, but they basically reached a truce. Right? Going back to, from the defense as a sports metaphor, now defense as a military metaphor. That each side could have ratcheted up the battle. Keep in mind what else is happening at that time. In 1802, 1803, you've got a massive world war happening. Right? So you've got France and Napoleon in Europe. So the military, so America couldn't afford at this young stage to have a full-out constitutional crisis when you have Napoleon and the English fighting a world war, and that could jeopardize the United States neutrality, right? And so there's a lot of reasons why a truce between the Democrats and the Republicans at this moment in American history was important. If you could simply say, okay, you'll keep the courts. Basically, Federalists in our system, you get to keep the courts. We're going to keep the presidency and Congress, and that's basically how the politics worked out for the next generation of American history with that kind of stability. And they negotiated and compromised, and neither side overstepped its bounds to make those moves. Isaac.
Just a question, not just about that. Yeah. You talked a little bit, or you talked a good amount about how politics relates to cases and rulings in the Supreme Court. Would you mind talking about or elaborating about why it makes sense, or why it was logical for Marshall to introduce judicial review in this case instead of Stuart v. Laird? Because in the context of the case, it makes more sense to introduce Stuart v. Laird, but like looking at historical context and some exterior factors, he decided to introduce it then. So
yeah, great question. So I actually went into the microfilm from February 1803 to look at when this decision was announced. And so when Stuart v. Laird was announced, I think they were announced right around the same time. Stuart v. Laird was the bigger case. It was the shorter case, but Stuart v. Laird was on people's. Stuart v. Laird was about judges. It was about all these appellate judges who were seen as being more important. More was at stake with Stuart v. Laird. So the Washington newspapers had Stuart v. Laird big, and then they had Marbury versus Madison very small. Why? Because who cared about Marbury was just a 5-year justice. He's basically a glorified cop, right? Who cares about a cop's job compared to the midnight judges, right? The circuit judges, the appellate judges. So not only was Chief Justice Marshall burying a judicial review in a way that prevented him, in this case, from giving someone his job, he buried it in the less significant case to the people watching the Supreme Court in 1803, right? So it is a hidden power, hidden because it's used to prevent him from doing something, and hidden in the smaller case, hidden in the hidden case. So it really is a move that is on paper simply signaling something that might happen in the future, but buried far enough under so many other bigger cases that it didn't trigger a backlash, right? And so it's not even clear whether anyone, Jefferson perceived these cases as being a win for him, being a big win, even if it hit something for the future. Matthew?
Could you also say that, I understand that makes a lot of sense, but could you also say that he may have chosen to establish judicial review in this case because it kind of worked out politically? Because if he had done it in Stuart versus Laird, then he would have been saying that they need to put all these justices, they need to put them back in their seats, and the Democratic Republicans would have been upset with that. But in this case, it was kind of satisfying to an extent everyone, because you kind of been talking about before, like
Yes.
the individual gains.
Right. So who knows what jujitsu is?
Karate, right?
It's a style, it's a martial art. What is the idea?
Using somebody else's force against them.
It's using someone else's force against them. It's using defense, right? Basically, you let someone attack you, and you use a retreat to be able to let their leverage let them get off balance. And so, one way to understand, this is not a perfect metaphor, but I think it works. Basically, Chief Justice Marshall retreats.
Matt.
Oh,
Sorry.
Chief Justice Marshall uses a surrender, a retreat, in this case, to let then Jefferson, she's trying to see if Jefferson's going to overstep, and let him see if he's going to, because it's not like the country is settled into one political arrangement. Jefferson is also has to be careful about how he uses his power. He can't have New England. I mean, imagine, the country is only 13 years old, right? And if the country's 13, 14, I mean, it's just had its bar mitzvah, right? And so, is it really, right? So, and so, at this moment, it's not clear. The country hasn't stuck together for a century or two. If Jefferson oversteps his bounds, it's not obvious that New England won't break off from America. In fact, there's something that happens in another bar mitzvah later. So in 1814, right? So add another 13 years to American history. There's something called the Hartford Convention. After a generation of losing elections, after Jefferson and then Madison has won his election, New Englanders get together at something called the Hartford Convention. They talk about seceding from the Union. Has anyone heard of that? Okay. So that Jefferson knows that he doesn't have jets and tanks. All he has, Jefferson also has to worry about legitimacy to keep the country together. He doesn't want to start his own civil war. So basically, the jujitsu move of Marshall is to surrender here, let Jefferson accept a win, and by endorsing and accepting the combination of Stuart versus Laird and Margaret versus Madison as short-term wins, Marshall gets the jujitsu move of the long-term power. And he also, and what I'm telling you is he uses that power carefully too. He doesn't strike down federal statutes. He uses that power to strike down state statutes. That's an easier move constitutionally. So where is judicial review in the Constitution? Like where does
Article 6.
Yeah, Article 6. Eric, where is it?
That's what I was going to ask.
Great.
We talked a lot about does the Constitution have supremacy
Yes.
of other laws, and I want to know. I'm sure you're going to get into it right now.
But is it explicit?
No.
So where do you see it in Article 6? This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, shall be the supreme law of the land. And the judges in every state shall be bound thereby. So it specifies the judges being bound by it. Now, one reading of the Supremacy Clause is all it does is it says that the federal Constitution and federal laws are supreme versus state laws. But at the same time, if it lists the Constitution first, it then asks the question, it leads to the question, what is a Constitution? A Constitution has to be a set of rules that are supreme over legislation. So it's implicit. It mentions judges in the Supremacy Clause, but it really is more clear in the Federalist Papers and other documents. The kind of move you have to get to really say that there's judicial review is originalism. And I am an originalist. You can have liberal original. I'm a liberal and I'm an originalist. You can have liberal original. Conservatives aren't the only people that own the history of the Constitution. You can find great purposes and progressive purposes in the Constitution as well as original conservative purposes. It's an equal opportunity document if you take the history seriously. So other questions? Direct here or bigger picture questions? Yes, what's your name again?
My name is Adine. Thomas Jefferson talks about all the branches of the government having judicial review, like for themselves. He says each department is truly independent of the others and has equal right to decide for itself what is the meaning of the Constitution in the case it's submitted to its action, and especially where it is to act ultimately and without appeal. And then kind of like the Federalist opinion is that only the Supreme Court gets this judicial review.
Right.
Do you think that judicial review and only the Supreme Court having it upsets checks and balances or adds to checks and balances?
So I'm actually thinking a lot about this right now, because there is a question of whose job is it to interpret the Constitution, and do presidents, do states? So one question is, can you have state nullification? Right? Can states nullify? The problem there is that the nullification or the Virginia, Kentucky resolutions, they threaten the Union, right? If you have a supremacy clause, it means that the federal government, constitutional laws, take supremacy over the state. But what about, so here's an example. So President Trump wanted to not follow the ACA, the Affordable Care Act, Obamacare. Can the president ignore a law, right? I thought, the supremacy clause says the Constitution and the laws shall be the supreme law of the land, but the president also has the power over executive power. So the thing that I'm working on now is this other part of the Constitution that says the president, this is Article 2, the president shall take care that the laws be faithfully executed. And who mentioned the oath over, someone mentioned
the oath only say defend the Constitution?
Let's look at the oath, right? So the oath actually says the president takes an oath to faithfully execute the office and to preserve, protect, and defend the Constitution. So Eric, you just highlighted, I think, one of the challenges of trying to understand what the president's role is. The president shall take care that the laws be faithfully executed, which means that he's got to follow through on what Congress passes. In the history, we looked at, a couple of co-authors and I dug into the history of trying to figure out what that meant. Basically means the president can't ignore laws. The president has to enforce the statutes, the laws that Congress passes, can't ignore them. And then takes an oath to faithfully execute the office. And what do you mean by faithful? This is going to get religious again, right? But it's not just a religious commitment being faithful. It also is a role that someone has to play in deferring. And so to answer your question, there is an argument that for a president to faithfully execute the laws means that he can't sabotage. Trump and Obama did this. It was both sides did this. Obama took the law that was passed by Congress in the ACA and he ignored the timeline of how the ACA should get implemented. He just waived. The statute said, insurance companies have to do this and people have to do that, and Obama just ignored those parts of the law. So Obama was not faithfully executing his own Obamacare statute, his ACA. And then he sets a bad precedent on not enforcing the ACA as Congress passed it, and now Trump wants to not enforce the individual man. I don't want to get into too much detail, but Trump is doing something similar from the opposite side, to weaken the ACA. And so the thing that I'm working on now is trying to figure out whether the Constitution tells Obama and Trump that they can't do that the president can't, just because they say that they've got an interpretation of the Constitution, once the court rules that the individual mandate, the rule that people have to buy health care insurance, once the court rules that's constitutional, a president arguably should not be able to second guess a court ruling. To preserve and protect and defend the Constitution could be interpreted to mean preserve, protect, and defend the Constitution as the Supreme Court has interpreted it because of the role of the supremacy clause. But let me just tell you that that's a very fraught debate, and there are arguments you can make on both sides.
I wish we could continue this. I'm sorry.
Right,
I know, just because it's starting to get really, really good. Thank you so much for joining us today. Yes, it really, really helped. Really interesting, and I'm hoping you'll be willing to come back and entertain more questions as we keep moving forward.
And if you'll have me back and figure out how to erase all this mess.
We will take care of that for you. Thank you guys so much, and you guys need to go to your next class before I get in trouble. So thank you so much.
Yeah, thanks. Great questions. We barely
Also, this
got.
class does not end at 10:45.
And we're 10 to 10:40.
Oh, now I am in trouble. Okay, well, thanks for telling me. Bye, guys.
Let's take a picture of you.
Yeah.